Well, friends, we got a bit of a sneak peek at just some of the evidence that will be introduced against Donald Trump in his Georgia state RICO prosecution, because some of his co-defendants who pleaded guilty, flipped, and are expected to testify against him gave the prosecutors videotaped statements, and the press got a hold of those videotaped statements. Y'all, Glenn Kirshner here. So friends, you've probably seen some of the new reporting about 4 co-defendants in Donald Trump's Georgia state RICO case. These are Donald Trump's criminal associates, his co-conspirators. We already knew that they had pleaded guilty, flipped, and agreed to cooperate with prosecutors. They agreed to testify truthfully against Donald Trump and the other co-defendants. And as part of that guilty plea process, one of the things that these 4 co-defendants, now cooperating witnesses, did was they provided videotaped statements of the testimony they could give against Donald Trump and others. Well, now, these videotaped statements were obtained by the press. But when you watch and you listen to some of the evidence that will be provided, that has been provided by people like Kenneth Chesbro and Sidney Powell and Jenna Ellis, it is really interesting and really incriminating. Headline: Key takeaways, highlights of the Fulton County DA interviews with Trump defendants. And that article begins, before they pleaded guilty in Fulton County's wide-ranging election subversion case, 4 one-time Donald Trump allies recorded testimony with prosecutors. Video of those interviews were provided to attorneys to the remaining defendants in the case as part of pretrial discovery. Known as proffers, such testimony is a preview of what witnesses might testify at trial. Portions of the videos were obtained by the Atlanta Journal-Constitution and other media outlets this week. Here are the key takeaways from the videos. Jenna Ellis. Comments Ellis made about an interaction she had at a White House Christmas party could help speak to the plans of the former president and those of the people around him. On December 19, 2020, Ellis, then senior legal advisor for the Trump campaign, ran into senior Trump aide Dan Scavino, who thanked Ellis for her work. Quote, I said something to him like, well, I'm sorry that we haven't been able to do more. And I emphasized to him I thought the claims and the ability to challenge the election results was essentially over because of the dismissal of the Texas versus Pennsylvania case from the United States Supreme Court, she told Fulton County prosecutors, according to video obtained by the AJC. Quote, and he, Dan Scavino, said to me in a kind of excited tone, well, we don't care, and we're not going to leave. And I said, what do you mean? And he said, well, the boss, meaning President Trump, everyone understood the boss. That's what we all called him. He said, the boss is not going to leave under any circumstances. We, and friends, please put a pin in that pronoun, we are just going to stay in power. And I said to him, well, it doesn't quite work that way, you realize. And he, Dan Scavino, said, we don't care. We don't care that we lost. We are just going to stay in power. Friends, let's talk about Jenna Ellis's expected testimony against Donald Trump. But let's start with this Dan Scavino character, right? Because Jenna Ellis said, Dan Scavino told me that the boss, Donald Trump, said, we're not leaving. We are just going to stay in power. We intend to stay in power, notwithstanding the fact that we lost the election. Who is this Dan Scavino character? Well, I know this will shock you, friends. Dan Scavino started out as Donald Trump's caddy. He was also an assistant manager for one of Donald Trump's golf courses. Donald Trump would go on to promote him to be manager. Dan Scavino was also a Coca-Cola sales department guy. He was a pharmaceutical company rep. And then with that resume, he ended up as White House Director of Social Media. He would go on to be the Deputy Chief of Staff for Communications. There was a USA Today article that talked about how he would even at times send out tweets from Donald Trump's account, some of the daytime tweets and some of the tweets without spelling mistakes. And Scavino's name may also be familiar to you because he was another one of the guys who criminally defied a congressional subpoena from the January 6th House Select Committee rather than have to testify about the crimes of Donald Trump. Scavino, Mark Meadows, Jim Jordan, none of whom have been held accountable for those crimes, all of whom committed contempt of Congress by defying congressional subpoenas. You may also recall Dan Scavino and Mark Meadows were specifically referred to the Department of Justice for prosecution for contempt of Congress, and for reasons that nobody can adequately explain, neither Mark Meadows nor Dan Scavino were ever charged for crimes, the crimes they inarguably committed. You may also recall Dan Scavino and Mark Meadows were specifically referred to the Department of Justice for prosecution for contempt of Congress, and for reasons that nobody can adequately explain, neither Mark Meadows nor Dan Scavino were ever charged for crimes, the crimes they inarguably committed. Contempt of Congress, refusing to appear, refusing to testify about the crimes of Donald Trump, democracy-busting crimes. Neither Scavino nor Meadows, thus far, has been held accountable for those crimes. So friends, let's talk about the import, the significance of Jenna Ellis's statement that Dan Scavino said, the boss said we're not leaving, we're not relinquishing power, even though we lost the election. In fact, Dan Scavino said, we are not leaving, and we don't care that we're supposed to leave. So in order to talk about sort of the evidentiary importance of statements like that, we're going to have to do a quick Team Justice Law School class on two legal concepts: hearsay and conspirator liability, co-conspirator liability, which in a nutshell provides that if you're in a conspiracy, you are guilty of, you are responsible for all of the crimes of all of your fellow co-conspirators, whether you directly participated in those crimes or not. But let's start with hearsay. So when we see on video Jenna Ellis saying, Dan Scavino told me that Donald Trump told him that we're not leaving power, even though we lost the election. We have to break those two layers of statements down. When Dan Scavino tells Jenna Ellis, we're not leaving power, that statement is admissible at trial against Dan Scavino. Why? Because any statement made by a defendant is admissible against that defendant at trial as what's called a statement by a party opponent. So if Dan Scavino was on trial, Jenna Ellis could come in and testify, Dan Scavino told me we were not going to leave power. However, When Dan Scavino says Donald Trump told him that they were not leaving power, that's hearsay, right? That would be Dan Scavino saying Donald Trump said we're not leaving power. So in the ordinary case, and then we're going to talk about a conspiracy, in the ordinary case, Jenna Ellis could not be asked, what did Dan Scavino say about what somebody else told him, what Donald Trump told him? Ordinarily, that would be hearsay. It could be used against Dan Scavino, but it couldn't be used against Donald Trump. However, this is the beauty of co-conspirator liability. We as a society decided a very long time ago that when people come together and agree to commit crime together, that's more dangerous than just one person deciding to commit a crime individually. So when it comes to conspiracy charges, the law has evolved such that every co-conspirator is responsible for, can be indicted for and convicted of every crime committed by every other co-conspirator. If you're in this criminal agreement, you're assuming the risk that when your co-conspirators go out and commit crimes that are part of and in furtherance of the conspiracy, everybody is on the hook, right? That's supposed to address the enhanced danger posed by a bunch of people getting together and agreeing to do crime. There is another evidentiary fringe benefit. Stick with me here. I know this is down in the criminal law weeds. The evidentiary benefit is the admissibility of co-conspirator statements. So ordinarily, whereas Jenna Ellis couldn't be asked, what did Dan Scavino tell you about what other people said? Because that would be hearsay. Guess what? The hearsay rules basically yield when it's a charged conspiracy. What does that mean? Any of the statements made by any of the co-conspirators that were made during the course of and in furtherance of the conspiracy are admissible against all the co-conspirators. So basically, this is an exception to the hearsay rule. And now, you bet, Jenna Ellis could testify, Dan Scavino told me that Donald Trump said, we ain't leaving power. We don't care if we lost. We're not leaving. And that would be admissible against not only Dan Scavino, but against Donald Trump and anybody else who was a member of the conspiracy at that time. That is the beauty of co-conspirator liability. It's pretty expansive, and it gives prosecutors some exceptions to the hearsay rule. So it is really important testimony from Jenna Ellis that Dan Scavino and Donald Trump said, we ain't leaving. Let me go back to that pronoun. Remember I said, please put a pin in that pronoun, we. The fact that Dan Scavino said, we ain't leaving, and we don't care that we're supposed to, what does that provide? Evidence that Dan Scavino was part of Donald Trump's conspiracy to unlawfully, unconstitutionally, and contrary to the expressed will of the American voters, they were going to retain power. They aspired to be dictators, to be involved in dictatorial rule. And that pronoun we is really important and really incriminating against Dan Scavino. You know, it's an important piece of evidence that tends to show Dan Scavino had joined Donald Trump's conspiracy to unlawfully retain power. So friends, I know at this moment Dan Scavino is not indicted anywhere yet, but based on that little bit of information we saw in Jenna Ellis's proffer to District Attorney Willis down in Georgia, it sure looks like Dan Scavino should find his name as a marquee defendant on the wrong side of the V sometime soon. Whether it's Georgia, state of Georgia, V versus Dan Scavino, whether it's the United States of America, V versus Dan Scavino and the prosecution in Washington, D.C., we'll have to wait and see. But it sure looks like Donald Trump's former caddy, Dan Scavino, has bought himself a world of trouble. And it's time to hold him accountable, together with all of Trump's other criminal associates.